exchanged PowerPoints. We have wasted almost 2 hours trying to get this stuff done. And my orders to you are not aspirational. They're given for a reason. And when you don't follow them, then I have a way to remedy that. So the remedy is nobody uses no PowerPoints, okay?
If I could address the court, Charlie Matthews from Mr. Newton. In terms of what we had done here on our side.
Wowza. Now, I don't usually do this, but I'm going to ask both my guests the exact same question just because Judge Glanville there made a big ruling. He's tired of listening to, well, I didn't know you had an edit there and you didn't show me the edit here. He was very clear, Richard, when he said, straighten this up during the lunch break. He just ruled no one can use PowerPoints. Was that the right answer?
I think it's a perfectly fine answer. By the way, I hate PowerPoints in opening arguments, in closing statements. If you're a lawyer, you're arguing a case to a jury. You're not in a seminar giving a presentation. I don't understand the PowerPoints, but this judge said, listen, we gave you the guidelines for doing this. You had to exchange slides. They didn't do that. He gave them a chance to fix it. They didn't do that, and now he says, I love this line, my orders to you are not aspirational. You got to do what I say. I'm the judge. You didn't do it right the first time. You didn't fix it. PowerPoint's out of here.
Exactly. Now, it's going to be interesting to see what happens during closing arguments if, in fact, they exchange it, if he allows them to do it at that point. Jeffrey, same question to you. I think it was a huge ruling. Was it the right ruling?
I agree it was a huge ruling, and I have a different answer than Richard, respectfully. I think it's the wrong ruling. I think the judge has every right to be angry. I wanted this resolved a week ago. It wasn't. I told you exactly what I wanted done at lunch. You didn't do it. I'm furious at all of you, and I want to take action. However, striking visual aids helps the defense because they don't have the burden of proof, right? His ruling before lunch was, look, if there are inaccuracies in the state's slides and you bring them to her attention and she doesn't fix them, then those slides are excluded. Now, basically what he's done is prevented the state, who has the burden of proof, from using any slides to try to clarify what it is they intend to prove over the course of a long trial, and basically done it because he got particularly angry at the defendant. I would have excused the jury for the day, even though it pains him to do it, and said, we're going to get this fixed. And in the morning, we're going to start opening again. In other words, the state picks up from where they left off, and we're not going to have interruptions like this again. That's what I would have done were I the judge.
Exactly. Richard, did you want to say something else? You look like you want to say something else.
So I think there's merit to what Jeff is saying, that this may be overly harsh on the prosecution, but this ruling isn't just about the opening statements. This is the judge at the beginning of the trial saying to everybody involved, you are going to do what I say. You are going to follow my orders, and if not, there are going to be consequences. And I think it's about much more than the opening arguments, opening statements, and I totally understand where the judge is coming from.
Exactly. Maybe he's trying to set the tone so it doesn't happen again. I just wonder myself, is that a ground for appeal? We're going to take a quick break, and when we come back, we'll have more for you on the case against YSL. Stay with us. All right, I have with me trial attorneys Richard Schoenstein and also Jeffrey Simon. Richard, I'm going to start with you. Lots of argument here. Can you use this shirt? Can we use these pictures? Can we use the slides? I think the slides are still out, correct?
It seems that to me, one of the many reasons I never use slides in an opening statement is I don't want to show the other side what I'm going to say in advance of even getting there. I don't want to give them my outline and my argument. I don't want to be subjected to this nonsense of pecking at each one and saying this is in, this is out, this needs to be edited. No, stand up, deliver an organized, persuasive opening statement, sit down.
Exactly. No, I couldn't agree with you more, although I think sometimes juries do need to follow the dots, and it's good to do it in the beginning if you can, as long as you're very clear with it.